Court rise.
Before, Mr. King, before you begin, maybe we would like your assistance on one or two points. Just give me a moment.
Mr. King, we have one or two questions.
Oh, sorry. I
I'm
wasn't
so sorry. I'm so sorry.
Thank you.
You're welcome to stand if you wish, but it's not necessary. Sorry, I'm just... give me 1 second. Right. Just before the adjournment, we were considering, or you were making your submissions in relation to the role of Article 6 in the court's consideration at the domestic level, the fairness of the proceedings. And there is, and I think Mr. King pointed us to some authorities on the issue of when and in what circumstances the court could, as it were, at the domestic level, decline to follow Strasbourg. Is it any part of your submission in this case to say that this is a path that we should take, or is it your submission that we can note what Strasbourg says, for example, about facts and its factual analysis, and depart from the way it is put in Strasbourg, which effectively would what we were doing, because we're looking at a different question, which is safety, rather than Article 6 fairness?
The latter, my lady.
During the course of argument this morning, I think I put to Mr. King that there had been some further dicta from the Supreme Court about the extent to which one had to follow Strasbourg authority, and I mentioned the case of Pinnock. There's another case called Chester, Crown on the application of Chester and the Secretary of State for Justice, in which it was said that, particularly where the matter has already been to the Grand Chamber once, or as in that case, twice, it would have to involve some truly fundamental principle of our law or some most egregious oversight or misunderstanding before it could be appropriate to contemplate an outright refusal to follow Strasbourg authority at the Grand Chamber level. Is there anything you want to say about that, or in the light of your last answer, do you say, well, I'm not inviting you to do that?
I'm not inviting you to do that because the court's dealing with a different legal question, which is the safety of the conviction.
Yes, thank you.
Thank you.
Thank you very much.
Thank you, lady. Lady, if I could refer the court to paragraph 254 of the judgment of the European Court, where it deals with this issue of the relationship between the processes of the domestic court and the European Court. And it's says complaints under Article 6 about the investigation stage tend to crystallise at the trial itself when an application is made by the prosecution to admit evidence obtained during the pre-trial proceedings and the defence opposes the application. As the court has explained on numerous occasions, it is not the role of the court to determine as a matter of principle whether particular types of evidence, including evidence obtained unlawfully in terms of the domestic court, may be admissible. As explained above at paragraph 250, the question which must be answered is whether the proceedings as a whole, including the way in which the evidence was obtained, were fair. So, when we come to the issue of whether or not the court understood the jury system and whether that phrase that the court has referred to as latitude, or where the judge made they say that it was, I can't remember. Anyway, he didn't confine the jury essentially. They are looking at the proceedings as a whole, and part of that involves looking at the directions the judge gave at any one point. It doesn't necessarily mean that they're accepting that the interview or the interview and the statement, or not the interview, the interview and the statement would be admissible, but looking at the totality of the proceedings, including the directions he gave at any given point. It doesn't imply that they envisage a point where that particular statement of confession is admissible, because they're looking at the proceedings as a whole, and there are a number of factors in this case, and if I could refer the court to 265, where it says, where there are no compelling reasons for restricting access to legal advice, the court must apply a very strict scrutiny to its fairness assessment.
Can you just remind me, when you, the passage that was criticised by the Grand Chamber, was account taken of the part of the summing up to which Mr. Mably referred at page 15?
Sorry, I missed that.
Sorry, I was talking down to my page.
I'm a bit...
Page 15 of the summing up.
Yes.
It was a passage that Mr. Mably referred us to. This relates to paragraph 310 of the Grand Chamber's judgment. And the criticism that was made
Yes, where he the judge drew attention to the irregularities that occurred in the questioning, and then goes on to consider the trial judge's direction left the jury with excessive discretion.
Yes.
Now, as to the manner in which the statement and its probative value were to be taken into account, irrespective of the...
Because it follows that, doesn't it? It directly follows the passage.
I think if Mr. King, if you look at 169 in the judgment of the Grand Chamber, that's where the Grand Chamber sets out what they considered to be the material passages from the judge's summing up.
Yes,
It's 169 to 171. 2.
Yeah, where he talks about the potential, whether they think there's something said or done that makes it unreliable, but breach of the code doesn't automatically mean that it should be a rejection as the evidence.
Yes.
But
Thank
the
you.
point is, he, in fact, in that summing up, he has not dealt with what weight they might apply to it.
Passage quoted in paragraph 169, though, is a faithful reproduction of what the
Yes.
judge said.
Yes,
Yeah.
absolutely. So, and of course, the European Court takes the view that where there are there have to be compelling reasons to restrict access to legal advice, and that was one of the main issues that, in my submission, you know, as part of the overall assessment of the fairness of the trial, because there was no compelling reasons ever offered as to why he was treated the way he was. And furthermore, so the court is looking at the totality of things. The domestic court is the court that they don't interfere with the application of individual or domestic rules in relation to admissibility, but where there has been something admitted that's prejudicial to the applicant, and looking at the proceedings as a whole, then they will, or they have in this case, come to the conclusion that there was a breach of his rights, and because, and of course it is a serious matter because it's a fundamental right to have access to a lawyer, to be cautioned. These are critical and crucial in our justice system. And they were it was done in circumstances where there hasn't been a structure or a procedure to deal with that scenario, the way they behaved, and then there was no no explanation has ever been given as to why there were compelling reasons, or there may have been compelling reasons to deal with it in that way. So for those reasons, they've concluded that the overall, taking the proceedings as a whole, from investigation right to trial, there were, that his rights were prejudiced, and therefore there was a breach of his right of Article 6. And in terms of what's left, if one removes the offending statement, as it were, then the rule is, and in Dundon it can be seen at paragraph 15, where it states that in many cases breach of an Article 6 right will result in quashing of a conviction as unsafe, but that is not necessary to result in all cases. And there's an example of situation in Lambert where the chap had 2 kilos of cocaine valued at 140,000, and there was no potential innocent explanation for having that. Now, this is not that sort of case, because in my submission, when one looks at the remaining evidence, there are lots of potential explanations for why the appellant behaved the way he did. He was asked to run errands that could have been innocent errands. In fact, there was no evidence to say that it was actually the camera that the camera obtained was the one that on which were recorded the suicide information. Certainly not at the time that he took the camera. So to try and infer knowledge and intent from the circumstantial evidence that was available if one removes the statement it's not just a question of would there be enough to go to the jury, it's a question of whether that evidence is overwhelming. Now, in my submission, it's far from overwhelming and may, in fact, not even be sufficient to go to the jury. So it's important in my submission that the court looks carefully at what that remaining evidence is, and in assessing it, whether it takes the view that that evidence, taken together, is overwhelming. And that's the last sentence of the paragraph 15 there. If there has been unfairness because of a legal misdirection, but the evidence is overwhelming, then the conviction will be upheld. But if it's not overwhelming in my submission, then the conviction can't be said to be safe.
In making that assessment, we can take into account the inference that can be drawn from your client's decision not to give evidence, can't we?
Indeed, but again, that, well...
It might be said that the evidence, even excluding the statement, called for some sort of explanation from your client.
Yes, but of course, now, if the interview, one can't speculate, but if the interview had been excluded, as in my submission it should have been, then he may have given evidence.
I see.
So one can't jump to an automatic interpretation of
Yes, thank
that.
you.
Those are my submissions.
Thank you very much. Just rise for a moment. Thank you. Mr. King, Mr. Mably, we will reserve our decision in this case. A draft of the judgment will be circulated to the parties in advance for the purposes of correcting any spelling or other typographical errors, but not for re-argument. And if there are any submissions to be made in the light of the draft judgment, could they please be sent in the first instance to my clerk in writing. If the court wishes to receive further argument orally, it will say so, but otherwise there will be no need for the parties to attend at the handing down. Of course, that will depend on the outcome of the case.
Thank you
very much. Something else? Anything else?
No,
thank you.
Thank you very much. All
Court
right.
rise.